Xiangyan Ao here. Today I'll be talking about some common legal bases for processing personal data which are recognized by privacy laws. Not all laws require a legal basis for processing. They could, by default, allow personal data to be processed subject to certain exceptions. For example, children's data requiring verifiable parental consent, etc. But where they are required, the most common types of legal bases are as follows. Number one, consent. This will need to be the relevant data subject's consent, although it can be conveyed via a third party. The quality of consent differs from jurisdiction to jurisdiction. Some consents must be freely given, informed, and unambiguous, so watch out for those dark patterns. Others demand a clear statement or affirmative action, as opposed to silent acquiescence or even opt-outs. This is especially relevant to personal data that is defined as sensitive or falls within a special category. Consent may also need to be specific, so not bundled and must be separately obtained for distinct purposes. A key feature to consent is that it is usually accompanied by a right to withdraw one's consent, which must be as easily exercisable as giving it in the first place. Finally, note that consent requirements can be very nuanced. The method of obtaining it could require a certain format, specific contents to be included, or a local language that is not English to be provided for. Number two, legitimate interests. This usually entails a balancing test between the legitimate interests of the controller versus the data subject's rights and freedoms with regards to the data. Proportionality is usually a prerequisite to this basis. The onus is on the entity seeking to rely on it to prove that its legitimate interests outweigh any adverse effects or implications on the data subject in question. Number three, contract. This is where processing is required to perform a contract. Note that the contract in question must be between the relevant entity and the data subject. Also, there could be additional conditions that need to be satisfied, particularly if the data that is processed is sensitive or falls within a special category. This legal basis is usually of limited or no applicability to online marketing. Number four, legal obligation. This is fairly self-explanatory, and the only thing I would highlight here is that the processing must be required to comply with the legal obligation. If processing is disproportionate or more intrusive than what is needed to comply, then you could face potential challenges to invoking this ground. Number five, vital interests. This would be either the vital interest of the data subject or some other person, for instance, in a medical emergency scenario, or for public interest, or to protect a vulnerable individual. Number five, others. These span a broad pool of exceptions to consent, such as in a business transaction or performance of a public duty, including law enforcement. There may be other unique ones as well, such as legitimate use in India or a business improvement exception to consent in Singapore. If you are keen to understand more fully how these might apply to your business, feel free to reach out. As always, I'd love to help.